Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. We're doing part 2 in this video series right here, where we talk about how the pistol brace rule is essentially on life support, and it is. Now, we've gone through the real meat of the matter on video number 1, where we, of course, talked about the ruling and how this is all going to fall apart and how the Administrative Procedure Act is ultimately going to turn out to be the death nail to the pistol brace rule. Today, I want to talk to you about 2 things. Number 1, the remedies that may or may not stem from this ruling. And then secondly, is there even more fatal flaws? Because one of the concurring opinions is one that we should spend some time with. So today, let's do a little extra follow-up. Let's geek out a little bit more and let's talk about how much longer does ATF's pistol brace rule have left to live? Okay, so the case we're talking about again today is Mock v. Garland. We've talked about it before. This is actually a follow-up to this video right here where we really got into the meat of it, talked about the ruling, talked about how the Administrative Procedure Act is going to be really the death nail of this. But today I want to talk to you about 2 other things. Number 1, nationwide injunction. I know all of you are like, well, hey, we got a nationwide injunction coming. Not so fast. I don't think that's the case. Towards the end of the majority opinion in striking this rule down and then remanding back to the district court for further consideration on what sort of injunctive relief needed to be granted, I want you to pay very careful attention to what the court had to say about far more expansive injunctions. Although plaintiffs urged this court to conduct this analysis ourselves and enter a nationwide injunction, we declined to do so now. For preliminary injunctions, none of the prerequisites has a fixed quantitative value. Rather, a sliding scale is utilized, which takes into account the intensity of each in a given calculus. A preliminary injunction is an extraordinary remedy, and the burden of persuasion on all requirements is on the moving party. Although plaintiffs succeed on the first factor, others are yet to be determined. And so what the court's basically saying here is, yeah, listen, we've demonstrated that you have a likelihood of prevailing, but you need to persuade us in the other statutory and legal factors necessary to grant injunctive relief. Now, we're not going to bore you to death with all that stuff, okay? But here's some of the guidance that the Fifth Circuit is giving to the district court when this case gets sent back. It includes rulings such as, similarly, determining the scope of injunctive relief is better suited to the district court in the first instance. American courts of equity did not provide relief beyond the parties to that case, although an injunction could benefit non-parties as long as that benefit was merely identical. For that reason, nationwide injunctions are not required or even the norm. And, listen, the Fifth Circuit made a tough call here, right? That is that this final rule from ATF is complete garbage and needs to be checked out. Maybe they didn't want to bite off more they could chew, and they wanted to leave some of the dirty work to the district court. They clearly are punting this back down to the district court for them to determine the scope of injunctive relief. Again, they're providing guidance to that district court with language such as, the present case is also not the only one involving a challenge to the final rule. Multiple judges within this circuit have already issued injunctions against the final rule, following the initial one issued here, enjoining enforcement against members of various gun rights organizations. It is already uncertain how many persons are now subject to these injunctions or how the ATF would enforce the final rule against non-enjoined parties. There is a need for consistent application of the law, and this court may not have all the required facts. Accordingly, the district court is better situated to weigh the facts and fashion the most appropriate relief. And then specifically, the court's ruling is, for the foregoing reasons, we reverse the order denying a preliminary injunction and remand with instruction to consider that motion expeditiously. To ensure relative stability, we maintain the preliminary injunction pending appeal that the motions panel issued on May 23rd, as clarified by this merits panel on May 26, 2023. This court's injunction will expire 60 days from the date of this decision, or once the district court rules on a preliminary injunction, whichever occurs first. we direct the district court to rule within 60 days. So here's what the court's saying is that we're kicking this back for reconsideration. Anybody who had injunctive relief still has injunctive relief and will have injunctive relief at least for another 60 days until the district court figures it out. How many more people get included into that category of individuals? That remains to be seen. But as you can see, they are very clearly telling the district court, hey, nationwide injunctions do not happen in most circumstances and probably shouldn't happen here. So it's that reason. I'm not suggesting that a nationwide injunction is not the appropriate remedy. What I'm suggesting is it's an extreme remedy that most courts simply don't have the stomach to deal with, and that's essentially what the Fifth Circuit is telling the district court here. Now, the other thing I want you to be aware of from this ruling out of the Fifth Circuit is the concurring opinion of Judge Willett, okay? Now, I love common sense application to complex legal issues, and God bless Justice Willett here, because he has written an opinion that candidly, short, sweet, to the point, but I think really demonstrates, one, he does have a very good understanding of the operational functionality of firearms, and he actually likes to apply common sense. He opines that in addition to the constitutional deficiencies that we've talked about on this video here, as it relates to the APA and the way this rule was implemented and the complete end around from the comments section and all of that we talked about in the previous video, okay? He also suggests, hey, there's a lot more going on here, which is problematic as well. As he put it, I join the majority's careful opinion in full measure. I write separately because I suspect that the final rule would likely fail constitutional muster, even if it were a logical outgrowth of the worksheet idea that preceded it. Rearward attachments, besides making a pistol less concealable, improve a pistol's stability and thus a user's accuracy. Accuracy, in turn, promotes safety. Even for attachments that convert a pistol into a rifle under the statute, ATF has not identified any historical tradition of requiring ordinary citizens to endure a lengthy, costly, and discretionary approval process just to use accessories that make an otherwise lawful weapon safer. Well, that's fantastic, Judge, because no one's ever thought, no, actually everyone has thought of it. Anybody who actually has a little bit of common sense about the functionality of firearms has thought that. What I love to see is a judge who's willing to put it down in the order, as His Honor also stated. Instead, the NFA tends to regulate weapons that inflict indiscriminate destruction. Machine guns, short-barrel shotguns, and smoothbore weapons, and for that matter, explosives, grenades, and poison gas. Weapons that begin as rifles, too, are more difficult to keep accurate once the barrel starts shrinking. In my view, protected Second Amendment conduct likely includes making common, safety-improving modifications to otherwise lawfully bearable arms. Remember, ATF agrees that the weapons here are lawfully bearable pistols absent a rearward attachment. Congress might someday try to add heavy pistols to the NFA and the GCA, but it hasn't yet. These pistols are therefore lawful. Adding a rearward attachment, whether as a brace or a stock, makes the pistol more stable and the user more accurate. I believe these distinctions likely have constitutional significance under Bruin. And, Your Honor, I completely agree. In fact, that is one of the most succinctly and best worded arguments as to this, because we see this so frequently. Anything that makes the individual more proficient in the firearm is obviously going to be used for nefarious purposes. It makes the firearm more deadly. What it also makes is the firearm easier to operate and therefore easier and more useful in a self-defense situation, and also allows the user in a self-defense situation a better opportunity to put shots on their intended target and leave them off of the unintended targets. So as you can see, there's a lot going on in this opinion. Do we think that there's going to be a nationwide injunction that flows from this? I honestly don't. I really, really don't. Do I think that more people may enjoy injunctive relief? Yes. What do I think is going to happen in the next 60 days? I think that, as I mentioned on this video right here, the pistol brace rule is on life support, and it is about to die a very sudden death. The case, once again, is Mock v. Garland. We will put the links for it down below so you can read this opinion. There's a lot to geek out here. If you got any other questions about this or anything else related to our Second Amendment rights, now you guys should know how to contact Washington Gun Law by now, but if you don't, it's okay. That information is down there in the description box. In the meantime, I do want all of you to remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.